Good evening, one and all. We welcome you all to the International Conference on Psychology, Counseling, Guidance, Therapy, Interventions, Education, Environment, Health, Well-being, and Sustainable Development 2024, commemorating Azadi Ka Amrit Mahotsav, nation celebrating 76 years of independence, United Nations Sustainable Development Goals 2015 to 2030, as part of awareness and campaigns in collaboration with Sri Holistic Health Foundation India and Sri Research Institute Center for Art, Sciences and Wellbeing, along with international and national fraternity and all other collaborators. And also on the occasion of Psychology Month and Psychology Day at UN and Psychology Week by APA, we welcome you all once again to today's commemorations and sessions. So before we start our sessions, let's take the blessings of Almighty.
कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शत्रुबुद्धिविनाशाय दीपज्योतिर्नमोऽस्तुते दीपज्योतिर्नमोऽस्तुते शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः शुभं कुरुत्वं कल्याणम् आरोग्यं धनसम्पदः.
With the blessings of Almighty, we shall continue with today's sessions. Today, first we'll take up the session on mental health, laws, acts, and rules, and various other clinical establishment provisions available in the form of laws, acts, and rules by Sri Virendra Kumar M. Thakurji. He is an advocate, an RTA resource person, and he is also assistant professor in Computer Science Engineering Department, Govind Ballapant Institute of Engineering and Technology, and also he has been very active on this platform, and almost since he joined the platform, he is almost every day he is attending, and almost he has active presentations in the forum, contributing a lot at par with excellence. So we welcome you, sir, once again, as this is a crucial month we are celebrating with an occasion on psychology. So I would request you to throw some light and insights onto legal aspects on mental health and also the provisions of clinical establishment acts. So over to you for your presentation. Welcome you once again. You can now unmute yourself, start your videos and your presentation.
Yes, now I'm connected from both the devices. So since there was echo, so I have disabled voice on one. So I'll be using laptop for my presentation, and I'll be using mobile phone for audio. Am I clearly audible, sir?
Yes, sir. It's loud and clear.
Oh, okay, fine. Thank you, sir.
You can switch on your video as well.
Sure, yes. I'm switching on that. Let me open my presentation first.
All the participants are requested to fill the registration form, which is available in the form of polls.
Is my screen visible, sir, now?
Yes, sir.
Okay. So I'm starting. Well, just last week, we have seen in detail about the Mental Healthcare Act 2017. So in that, there were two questions. First was whether there are any amendments to this act. And second was regarding the rules made under the Mental Healthcare Act 2017. So earlier, what you have seen last week is the Mental Healthcare Act and how it differs from, say, Mental Health Act of 1987. So we have seen that in 20 years, there has been much change, and we have seen the objectives and what are the main differences between Mental Health Act as well as the Mental Healthcare Act. As far as coming now to the amendments that have been made, so I have carefully checked, firstly from the authentic website, that is India Code. So there have been no amendments to this act. There, of course, there is one amendment is proposed, but it was introduced in Lok Sabha and it has not yet passed. So I'm just displaying that it's actually a private member bill, and it is just a bill. It has not yet passed, so it is not an act. This was by Dr. Shrikant Eknath Shinde, Member of Parliament. It was introduced as Bill number 263 of 2022, and it has not yet become an act. So, but some small amendments were proposed. Mainly, we see that there was. I'm enabling my video also. Yes, I hope I'm visible now. Can you see that? Okay. So I'm
Yes.
able to see on another device. Okay. Now there are only few amendments that have been, say, proposed by Dr. Shrikant Eknath Shinde. This is just a private member bill, and private member bill can pass only if there is support of, say, majority of the parliamentarians present and voting. So what are the amendments that are proposed? Firstly is that in section 17 of Mental Healthcare Act 2017, some amendments have been proposed. So herein, after referred to as Principal Act, the words say interest, best interest, will and preference shall be substituted. That means, as far as we have seen that these people with mental health care have been given an option, that is whether they want to get themselves treated or not. That means it should not be imposed forcibly upon them by other people. Therefore, this change has been made that instead of this will, that is, what the word is, best interest. So who will determine what are the best interests of the patient? So in that case, it is proposed that best interest should be represented by will and preference, so that it is completely at the discretion of the person whether that person wants medical treatment, psychological treatment or not. So that is the first change that is introduced. Moving further, in section 3, that is of the Amendment Act. There is change proposed to Section 21 of the Principal Act. The following explanation shall be inserted. That is, for the purposes of this subsection, medical insurance. So as far as the insurance is concerned, so there are certain shortcomings in the present act that are failed. So medical insurance includes the indemnification of the insurer or the hospital in the cases requiring but not limited to, firstly, the hospitalization, then psychotherapy, medication, cognitive behavioral therapy, that is CBT, counseling, or any other form of treatment deemed fit for the patient by medical practitioner or a clinical psychologist. So this is the another, say, we can say, provision related to insurance that is supposed to be amended. Then there is slight amendment that is, say, suggested in Section 65 of the Mental Health Care Act, which is called here as the Principal Act. So for the first proviso of subsection 1, following proviso shall be substituted, namely provided that till the period the authority specify the minimum standards for different categories of mental health establishments, after due inspection of such mental health establishments by authorities, it shall issue a provisional certificate of registration to the mental health establishment. As far as this amendment is proposed, so that there should not be too much delay, that is, those who want to start mental health establishments, so they should be given firstly a provisional certificate, and after provisional certificate, they may complete all the necessary formalities, and after inspection of these formalities and all the paperwork or procedural work is done, then they may be given a permanent, say, registration. Like, so this is supposed in Section 65 as far as the establishments, that is, this medical mental health establishment are proposed. So this is the change that is proposed. So again, it is yet a bill, it is not yet passed, but these are the only changes that have been proposed. Coming to the rules. So as far as the rules are concerned, there are three main rules that are there. This is actually the main act from which I prepared the presentation. So I will be going back again to that, because I think we should know the substantive provision first rather than the subordinate provisions. And there are no regulations as such, but regulations as far as the state mental health authorities are concerned. So like in Uttarakhand, some authorities have, some states have proposed certain, say, regulations also. So as far as these three acts are, three rules are concerned, so if we see what are the rules that have been already published in the Gazette of India. So firstly, it is related to Central Health, say, authority, that is Kendriya Swasthya, say, Manasik Swasthya Pradhikaran. So we have seen that there is actually a provision for central as well as state mental health authorities, and therefore I am coming to this English version. So there are two, say, authorities at two levels, that is at the central level as well as the state level. So there are rules that are called as mental health care, Central Mental Health Authority and Mental Health Review Board's rules 2018. So there is not only the provision for Central Mental Health Authority, but also for the mental health review boards. Now, what are the powers of these and functions of these? These have been defined under the Principal Act. So we shall be anyway going back to that presentation, where I would briefly mention about these different provisions that have been made. Second are the set of rules that are made. I'm switching to that. These are published again in 2018 on 29th May. So these were also published on the same day, that is 29th May. Again, I'm going to the English version, and the second version that I have found, these are of, say, again under Mental Health Care Act, and these rules also prescribe certain forms. So this is as far as the rights of the mental health care patients are concerned. We have seen that there is whole chapter related to the rights of mental health care patients. So what are those rights and how they are supposed to implement those rights? So for that, certain rules have been enacted by the central government, and these rules have come into force. So these rules may be called the Mental Health Care Rights of Persons with Mental Illness Rules 2018. So several rules are proposed, and many different forms have also been prescribed. That is how they would choose or opt for this mental health care treatment. So for that, this is the second set of rules that is there. And see, there are different types of forms that have been designed for use by the patients, by the hospitals. So these forms have also been prescribed by the central government. So this is the second set of rules. Coming to the last, that is the third set of rules. Again, these have been prescribed in 2018. I am switching to that. These have also been published in the Gazette, that is Rajpatra. So in the Gazette of India, these rules have been published on 2018, and these rules are related to the State Health Care Authority, that is Rajya Manasik Swasthya Pradhikaran Niyam 2018. Again, these have been published on the same date, that is all the three rules were published on 29th May 2018, and it is also prescribed that they would come into effect from the date of publication in the Gazette. So these have already come into effect on 29th May 2018. That is the date of publication in the Gazette. This third set of rules, again, I am going to the English version. So these rules also prescribe certain forms, and these are related to the State Mental Health Authority. So State Mental Health Authority, say mental health care, State Mental Health Authority rules 2018. These are there. That means, as far as the subordinate legislation is concerned, so there are only three rules. As far as the amendment is concerned, so there are no amendments that have come into effect, but only in three sections. Some amendments have been proposed in 2022, and that bill was introduced in Lok Sabha, but it has not yet come into an act. And so this is as far as the latest, we can say, changes that have been that were discussed in the previous presentation. Coming to the Mental Healthcare Act 2017, that day we had discussed about this several objectives and what are the differences, that is revisions made from the previous Mental Health Act of 1987, that was 20 years before. So we have already gone through in detail about the various changes that have been made, and broadly we have discussed about the provisions. We have seen that there is also this concept of advanced directive. We shall see actually what are those provisions that are there in the Act, and there are also mental health establishments. We have seen that there is central and state mental health care authority, as well as there are certain boards that have been there. Admission of persons with mental illness. So procedure and process for admission there is there. Treatment, subsequent discharge of mentally ill persons. Then we have seen about the shock treatment or electroconvulsive therapy. So last time we have seen that this attempt by mental health care patients is decriminalized. That is section 115. So it has overriding effect as compared to IPC 309. And we have seen that even IPC 309 will be abolished because Indian Penal Code will be repealed with effect from 1st July 2024, when the Bharatiya Nyaya Sanhita BNS 2023, which has already been passed by the Parliament, will come into effect along with the new CRPC as well as the new Evidence Act. So that is Bharatiya Nagrik Suraksha Sanhita and Bharatiya Sakshya Adhiniyam. So we are going to have entirely new set of rules for criminal justice system in India after more than 160 years. So that is going to be a major change as far as the criminal law is concerned. Now, responsibility of certain other agencies have been prescribed. So police has the responsibility. Financial punishment, we had seen the provision that there could be 10,000 or say 6 months imprisonment, or say fine of 50,000 to 5 lakh and up to 2 years imprisonment. So it's a minor criminal law. Then we have seen about the critical insight, that is what are the deficiencies of the present act. We have today seen about the present proposed amendments also that are proposed there in the 3 sections of the act. It's a very big act containing 126 sections, so divided into several chapters. Now, mental health services for all. So we have seen in this some statistics that at district level, sub-district level, and we have seen that only we have 40, at national level, the institutes or institutions taking care of mental health care services. And even out of them, not all of them, that is, they are differing in their services as well as the quality of service that is afforded. We have seen this concept of advanced directive. Today, we shall see some provisions related to it. This is a major chapter, rights of persons with mental illness. We have seen that this is further specified into the rules that have come into effect from 29th May 2018. So there are several rights that are given, and there is entire whole chapter related to rights of persons with mental illness. Then we have seen about some statistics, that is the depression. We have seen that it is one of the most common, mental ailment in India. And we have seen that our GDP spending is very less compared to, what international standards are there, or what is prescribed by the World Health Organization. or even as compared to other neighboring countries like Bangladesh. So that we have seen. Decriminalization of suicide, that is section 115. Patient-centric healthcare, that is a new concept, and even now they are not treated like criminals, but rather they should be treated like patients. So that is a major shift from the earlier act, and we have seen that in 20th century there was an act called Pagal Act 1911. Now that Pagal is considered very derogatory word, and we don't use that word nowadays. So these are called mentally ill persons. Then mental health for all. So this is the target, that it should reach to 1.3 billion Indians. So this act was enacted in 2017. Then right to access mental health care. So in that this several rights are there. Right to community living is another right. Right to confidentiality. Right to personal contacts and communication. These are several rights. That right to legal aid. These are the rights that are given. Coming back now to the scheme or the detailed provisions that we had not seen that day because of shortage of time, but we have seen the brief introduction to that. Coming to this structure of this act, we see that first chapter is preliminary, that contains short title, extent and commencement, and definitions. Chapter 2 has mental illness and capacity to make mental health care and treatment decisions. So how the determination will be made, that is given in section 3, determination of mental illness. Fourth is the capacity to make mental health care and treatment decisions. So in that, because sometimes the person may not himself be able to take decisions. So who takes decisions on their behalf? So that is prescribed in section 3 and 4, so that it is not say forcibly a person can't be declared as say mentally ill person. There is this concept of advance directive, which is a Western concept that is imported in India. So there is provision of advance directive, that is a person can nominate who will take care of that person when that person faces mental illness. So manner of making advance directive. Maintenance of online register that will list the name of the patient as well as their caretaker. Revocation, amendment or cancellation of advance directive. Advance directive not to apply to emergency treatment. So this is an exemption. Duty to follow advance directive, that is the wishes of the person should be say honored. Power to review, alter, modify or cancel advance directive. Then review of advance directives, and liability of mental health professional in relation to advance directive. So these are the provisions that are given in chapter 3 related to advance directive. These are the rights that is a person can nominate who will be their caretaker. The fourth one is nominated representative. So appointment and revocation of nominated representative is given in section 14. Section 15 gives nominated representative of minor. In such cases, the say, parents or guardians or wards, the guardians, so they are the say they can nominate their caretaker in case of minors. Then revocation, alteration, etc. of nominated representative by the board. About board, there is a separate chapter that we shall see later, and there are duties of nominated representative. So in these 4 sections, these duties of nominated representative have been prescribed. In chapter 5, there are rights of persons with mental illness. So several valuable rights have been given as legal rights now. So these rights are a major shift from the previous acts in India, we can say. So right to access mental health care is the first right that is given. Another legal right is right to community living. That is, they should not be forcibly separated or live in isolation. Right to protection from cruel, inhuman and degrading treatment. That is, there should not be forcible chaining or say even we shall see about shock treatment, that is electroconvulsive therapy. Right to equality and non-discrimination. Then right to information about their say health status. Right to confidentiality, that is includes privacy of their say exact illness. Restriction on release of information in respect of mental illness. And right to access medical records, so they should have access to the medical records. Right to personal contacts and communication. And then right to legal aid, and right to make complaints about deficiencies in provision of services. So these are the say we can say 11 rights that are given to the persons with mental illness. Coming to the next chapter, there are duties of appropriate government. So certain duties have been prescribed for the central as well as the state government. In section 29, we see there is promotion of mental health and preventive programs. So these are have to be prepared by the government. Section 30 is about creating awareness about mental health and illness and reducing stigma associated with mental illness. So we have seen that to destigmatize, some say changes have been made in this as compared to the previous older act of say 1987. Appropriate government to take measures as regard to human resource development and training, etc. And then coordination with appropriate government. So these are the 4 sections that are there in the chapter 6. Next we see there are 2 different authorities, or rather authorities at 2 different levels, central and the state government. So in India we have 3-tier structure, and here we have central as well as the state mental health authority, plus there are boards also. There are separate chapters for all of these. So section 33 states about the establishment of central authority. Section 34 is composition of central authority, that is given. 35 says about the term of office, salaries and allowances of chairperson and members. Section 36 is about resignation. 37 is about filling of vacancies. 38 is vacancies, etc., not to invalidate proceedings of central authority. Section 39 is member not to participate in meetings in certain cases. 40 is about officers and other employees of central authority. 41 is functions of chief executive officer of central authority. 42 is about transfer of assets and liabilities of central authority. 43 gives the functions of central authority, and 44 gives the meetings of central authority. Then we have state mental authority, health authority. This is similar to chapter 7, but now this is at the state level. So first there is establishment of state authority. Their composition is given in section 46. 47 is term of office, salaries and allowances of chairperson and other members. Section 48 gives about resignation. 49 is about filling of vacancies. 50 is about vacancies, etc., not to invalidate proceedings of state authority. 51 gives member not to participate in meetings in certain cases. 52 is about officers and other employees of state authority. 53 is functions of chief executive officer of state authority. 54 is about transfer of assets and liabilities of state authority. 55 is functions of state authority, and 56 is meetings of state authority. So this chapter is analogous to say comparable provisions for the central mental health authority. So similar are the provisions for the at the state level for state mental health authority. We have seen that there are also rules that have been enacted and come into effect from 29 May 2018. So these 2 sets of rule, one is for central mental health authority and another is for state mental health authority. Coming to chapter 9, this is about finance, accounts and audits. So there are grants by central government to central authority, central mental health authority fund that is maintained, accounts and audit of central authority. This is maintained by CAG, Comptroller and Auditor General of India. Annual report of central authority laid before the Parliament. Grants by state government. Similarly, state mental health authority fund. For that, we have accountant generals at state level in India. Accounts and audit of state authority, and annual report of state authority that will be laid before the respective state assemblies. So this is about chapter 9. Chapter 10 is about the mental health establishment. Now, as far as the participation of non-governmental organizations or their registration is concerned, so the government also takes care of this private sector, because the government can't look after all the things, and therefore this registration of mental health establishment is to be done by the regulators. Then procedure for registration, inspection and inquiry of mental health establishments, then audit of mental health establishment, then inspection and inquiry, appeal to High Court against the order of authority, that is whether it is central or state authority. Then so authority here would act as a quasi-judicial body, and their orders can be challenged before the High Court. Certificates, fees and register of mental health establishments, and maintenance of register of mental health establishment in digital format, and duty of mental health establishment to display information. So these are the say provisions as far as the mental health establishments are concerned from section 65 to 72. Coming to chapter 11, there is provision for mental health review boards. So constitution of mental health review boards is given in section 73. Composition of board is in 74. Terms and conditions of service of chairperson and members of board is given in section 75. 76 gives about the decisions of authority and board. 77 is applications to the board. 78 is proceedings before board to be judicial proceedings. So it has the judicial powers. It can do the hearings. And then meetings. We can say these boards are rather the special courts that are established under this act. Proceedings before board, and central authority to appoint expert committee to prepare guidance document. Then powers and functions of board are there. and appeal to court against order of authority or board. That is, the orders given by the board are appealable to the High Court, and then grants by central government to this board. So this is about chapter 11. Chapter 12 is about the admission, treatment, and discharge of patients in mental health care institutions. So there is admission of person with mental illness as independent patient in mental health establishment. There is independent admission and treatment, admission of minor, discharge of independent patients, admission and treatment of persons with mental illness with high support needs in mental health establishment up to 30 days. That is the supported admission. And if that person has to be kept beyond 30 days in that institution, then the admission and treatment of persons with mental illness with high support needs in mental health establishment beyond 30 days, that is supported admission beyond 30 days. So what happens is, sometimes they are forcibly declared as say madmen or person with mental illness by their family members, or because they don't want to look after their care. So sometimes they may forcibly them admit. So this should not happen, and therefore there is independent admission and treatment that is done, and admission, treatment, and discharge is regulated with this provision. Sometimes some criminals also say feign like patients, so that they should get rid of the imprisonment or jail, and it is better to spend time in say hospital rather than jail, and therefore they may pretend about their mental health and therefore there has to be independent admission and treatment as per section 86. So this is about chapter 12, by which say this past shortcomings have been sought to be treated. Then there is 91, that is leave of absence. Then absence without leave or discharge. That is after the person is admitted to the hospital, which we earlier called as lunatic asylums. 93 is transfer of persons with mental illness from one mental health establishment to another mental health establishment. Then 94 is emergency treatment. For emergency treatment, no consent or no advance directive is applicable, as we have seen earlier. Then there are prohibited procedures. So this shock treatment or electroconvulsive therapy. So certain procedures have been considered as inhuman, and they are prohibited under that. Restriction on psychosurgery for persons with mental illness, and then restraints and seclusion, because these are very harmful negative effects on the say persons. So it has to be restricted, and it should be only under expert supervision. Then discharge planning, and then research. So these are the this is chapter 12 related to admission, treatment, and discharge. Coming to chapter 13, responsibilities of other agencies. So certain other agencies have also been given certain duties. So there are duties of police officer in respect of persons with mental illness. That is, who is mentally ill. So to discover who is mentally ill person, for that there are certain duties of police officers. They would be able to do that and produce such persons
Virendra Kumarji, now you can use the alternative device as well.
Yes, yes. Okay, 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 okay. Now it is enabled. Suddenly I was facing problem because I was disconnected from one device. So thank you for making me co-host again. So I hope my presentation is visible again.
Yes, sir. Please continue.
Okay. So we are seeing about the responsibilities of other agencies under Chapter 13. So there are duties of police officers in respect of persons with mental illness. That is, whenever the persons discover that some people are wandering or they are in need of say mental health care, or they are being neglected by their family members, so they are supposed to immediately report to the magistrate of their area. So report to magistrate of person with mental illness in private residence who is ill-treated or neglected. So this is the duty that is given to the police officers, that is reporting to the magistrate. After that, conveying or admitting person with mental illness to mental health establishment by the magistrate. That is, the magistrate will take the decision whether that person needs mental health care and whether that is to be admitted. Then prisoners with mental illness. In these cases, the jailers or the wardens of jail or jail superintendents would take the decision. Then persons in custodial institutions. So in that, the superintendent of the custodial institutions, like say we have for women, for children, there is children protection home, we have women protection home. So in such cases, these are also custodial institutions. So there are both types of persons, that is criminal, non-criminal or under trial, as well as the abandoned or orphan people. So these people are in different types of custodial institutions. There are also separate institutions for convicted criminals. So in such cases, the superintendent of such institution will take the decision. And then question of mental illness in judicial process. That is, a person is really say mentally ill or not. So in that cases, the judges will take the decision whether a person needs mental illness, particularly those who are undergoing the criminal proceedings, whether they are doing it as a say to escape from the imprisonment or whether it is real case. So that decision is taken by the judges. Then coming to chapter 14, we see it is a small chapter, only one section. So there is restriction to discharge functions by professionals who are not covered profession. So there is so those professionals which are not covered by professional, or those who are disqualified, so they will not discharge any functions. And there is restriction that only if they are qualified, that is having some qualifications in psychology, psychiatry, or say social work or related disciplines, so they will be able to discharge functions under this act. Coming to the offenses or penalties, so we have seen earlier that this is a minor criminal law, and therefore there are penalties. We have already seen about these provisions. So penalties for establishing or maintaining mental health establishment in contravention of provisions of this act. This is punishable. Punishment for contravention of provisions of the act or rules or regulations made thereunder, and then offenses by companies. So there is provision from say 6 months to 2 years of imprisonment. It is also say fine from ranging from 10,000 up to 5 lakh rupees. Then coming to the last chapter, that is miscellaneous. So these are sections from 110 to 126. So there is power to call for information. Then power of central government to issue directions. Power of central government to supersede central authority. So it can even supersede the central mental health care authority if needed. Similarly, we have power of state government to supersede state authority. Special provisions for states in northeast and hill states. Then presumption of severe stress in case of attempt to commit suicide. In this, we have seen that this is something that decriminalizes the attempt to suicide by the mentally ill persons. That means they can't be say imprisoned for 1 year under IPC, as was the provision earlier. Then bar of jurisdiction. Since there are special boards that are prescribed under this, so the ordinary civil courts say have been debarred of their jurisdiction. There are transitory provisions because already the older act was there of 1987, so the transitory provisions are given here. And the chairperson, members and staff of authority and board to be public servants. So that is public servants, they are prosecutable. That is for corruption, etc. They can be prosecuted under section 21 of the Indian Penal Code. Then there is protection of action taken in good faith. So this is a provision, say protection from civil suits and from criminal prosecution to all the persons or say government servants who are taking some action under the provisions of this act. Then act to have overriding effect. Then power of central government and state governments to make rules, and we have seen already that some rules have been made and they have come into effect from 29th May 2018. So 3 sets of rules have been prescribed. That is, first is the rights of persons with disabilities rules, and there are also rights for central authority as well as the state mental health care authorities. Then power of central authority to make regulations, so they can also make the regulations. Then power of state authority to make regulations. Under this, in 2022, like in Uttarakhand, so several different state authorities have made different regulations. So each state can make its own regulations applicable in their own states. Then laying of rules and regulations. So of course they have to be laid before the parliament or the state legislature, as the case may be. Then power to remove difficulties. So whenever a new act comes into effect, so if there are certain difficulties, then within 2 years by notification, this government can remove the difficulties, and even that has to be laid before the House of Parliament, so that there is no need of amendment. After 2 years, this power can't be exercised and changes can be done only by an amendment to the act. Then there is repeal and saving. So the previous act of that is the Mental Health Care Act of 1987 is repealed, which had already repealed the previous act, that is Pagal Act of 1911, that was made during the British government. So these are the different provisions. Again, we shall not enter into the details of these provisions, but if there are any questions related to this, or related to different types of acts, we have discussed about this amendment bill. Similarly, we have the bill has not yet passed an act because it was a private member bill, and we have seen these 3 different sets. That is, beside the main act, there are 3 different rules that have been published in the Gazette of India, and these also have the force of law, that is subordinate legislations. So these rules have been prescribed. For as far as the state governments are there, so few state governments have made their own regulations at state level. As far as this last time there was one question related to 2020 amendment. So I have seen that there are no amendments, and that 2020 amendment does not apply to India. It is related to some international law. So maybe some person might have searched it from internet, but I have seen it from the authentic source, that is the India code, and I have seen that there is no such amendment. Only one amendment was proposed in 2022, and even that has not yet come into effect. So I'm stopping sharing here. If there are any questions, I would be glad to answer that.
Dear participants, feel free to share your feedback, queries, suggestions using chat box, or you can raise your hand as well so that we can unmute you if you have any. I think as of now, we don't have any queries.
Okay. Okay, so I'm thankful to Dr. Ravindra. I'm also thankful to Mary Madam for making me a phone call and reminding this about this important presentation, because I was very busy today. But in spite of that, since I had already prepared for this and last week also, so therefore I was able to make presentation. So I'm also thankful to Shri Holistic Health Foundation of India and Shri Research Institute and Center for Art, Science and Wellbeing for giving me this valuable opportunity to make a presentation. Thank you. And thanks to all the participants also for their patient listening.
Thank you, sir.
Thank you.
For the wonderful insights. Hope everyone is aware now, at least. Of course, we cannot be experts on one day or one session. But at least we are aware of various provisions that are there as part of the Act and law. And so, if time permits, shall we cover this Clinical Establishment Act or?
Yes. Clinical Establishment Act. So let me open another presentation.
Yeah.
It's also ready. I'm coming to that.
So this will help, the doctors or psychologists, psychiatrists, or psychiatric social workers to establish their own clinical practice independently or under a registered clinic or an hospital or establishment.
Yes, sir.
In the meanwhile, participants feel free. If you have any queries or suggestions, feedback, feel free to use chat box.
Yes, I have got that file. I'm converting it. So I would just take a pause of 5 minutes, and after that, I'll start my another presentation.
Yeah.
Is it okay?
So let's take a bio break for 5 minutes.
Yes, sir.
And let's everyone join back.
And I will let you know as soon as my presentation is converted to another file format. So I'm already ready with that presentation. So we shall start about the clinical establishments registration and regulation at 2010 in detail.
Yes.
Yes, am I audible? I'm ready. May we start now, sir?
Yes, sir.
Okay. So actually, my presentation was in PPT format, so I have converted that to this PDF, and I'm going to share it soon from my laptop, and I'll be using my mobile for audio. So I hope my audio is clear. I'm sharing the presentation now. I'm already co-host on the other device, and this I have shared. Yes, I hope now it's visible, sir.
Yes, sir. Please continue.
Okay. Thank you. So now we shall see another important legislation, that is the Clinical Establishments Registration and Regulation Act 2010. This is very important for all social workers or psychologists or say any persons or even physicians who want to establish their own clinical establishments. So health is there in concurrent list. We have health ministries at the central level as well at the state level in India. So there is jurisdiction by both. This is a central legislation that is there. So there are several laws for doctors in India that are there. Firstly, there are COVID-19 guidelines on dead body management. Telemedicine guidelines have been issued on 14th May 2020. There is Consumer Protection Act 2019, and there is also some controversy regarding whether doctors should come under this act or not. But it has been held by courts that it is a service and there should not be any deficiency. So even Consumer Protection Act covers that. There is National Medical Commission Act 2019. So earlier in India, we had MCI, Medical Council of India. So that has been abolished. And instead of that, now we have NMC, that is National Medical Commission Act. Then there is Surrogacy Bill of 2018. There is right to privacy judgments of Supreme Court related to medical treatment and say several diseases. There is Clinical Establishments Registration and Regulation Act 2010 that we are going to see today in detail. There is also Food Safety and Standards, that is Contaminants, Toxins and Residues Regulations 2011. Food Safety and Standards Prohibition and Restrictions on Sales Regulations of 2011. These are several laws that are applicable on doctors. Then we have Prohibition of Sexual Harassment of Women at Workplace Act 2013, that is POSH Act, that is also applicable to all establishments. There is Marriage Laws Amendment Bill 2010, Protection of Women from Domestic Violence Act 2005, Food Safety and Standards Regulations. So we have FSSAI authority also in India. Mental Health Act 2017, Consumer Protection Act and Medical Profession, actually Mental Health Care Act, Environmental Act and rules are applicable, and Transplantation of Human Organs Act and rules of 1994. So although it's a state subject, but on request of three states, the central government had enacted this Transplantation of Human Organs Act so that there is no commercial selling of say kidneys or say other human organs. So and there should not be any human trafficking because of this. So to prevent this commercialization, this is a strict legislation that is enacted in India. There is also Pharmacy Act 1948, the older acts, Biomedical Waste Management and Handling Rules 1998, Drugs and Cosmetics Act 1940, Prevention of Food Adulteration Act 1954, Narcotic Drugs and Psychotropic Substances Act 1985 and rules, Maternity Benefit Act 1961 and rules, Insecticides Act and rules. There are acts in disability. There is PNDT, that is Prenatal Diagnostic Techniques Act 1994 and rules, which regulates the ultrasound for pregnant women. There is Medical Termination of Pregnancy, that is MTP Act 1971 and rules. So these are the several rules that are applicable on doctors. Out of that, today we shall see one important legislation, that is an act to provide for the registration and regulation of clinical establishments in the country and for matters connected therewith or incidental thereto. Whereas it is considered expedient to provide for the registration and regulation of clinical establishments with a view to prescribe minimum standards of facilities and services which may be provided by them, so that mandate of Article 47 of the Constitution for improvement in public health may be achieved. This is one of the directive principles of state policy, and therefore to give effect to that, this has been enacted. And whereas Parliament has no power to make laws for the states with respect to any of the matters aforesaid except as provided in Articles 249 and 250 of the Constitution. That means in India, we have got three different say list under 7th schedule, which is we call as the legislative competence. So in some cases the central government has the powers, in some cases the state government has the powers, and there is also concurrent list. Uh, uh, that is the third list, in which the central as well as the state government has the powers to enact the laws. But we have seen, like in Transplantation of Organs Act, so if the say state government makes a request, then the central government do the legislative work for them on special request. And whereas in pursuance of clause 1 of Article 252 of the Constitution, resolutions have been passed by all the houses of legislatures of the states of Arunachal Pradesh, Himachal Pradesh, Mizoram, and Sikkim to the effect that the matters affected aforesaid should be regulated in the states by parliament by law. That is, for other states, it is optional. That is, if they want the ready-made law, they can make it applicable to their states, because the central government does not have power to make rules for all the states as far as the health matters are concerned. So the Central Act has been enacted, and if any state government wants, they may make applicable in their respective states by bringing a resolution in their assemblies. So be it enacted by Parliament in the 61st year of the Republic of India as follows. So on the request of this state, say 5 states, this act has been enacted by these 4 states, that is Arunachal Pradesh, Himachal Pradesh, Mizoram, and Sikkim. First, we see this act may be called the Clinical Establishment and Registration and Regulation Act 2010. As far as the state laws are concerned, so the states which have their own laws, they are also similar to this, and therefore study of the Central Act would help us to understand what may be the rules in the respective states, because they are also similar to these provisions. It applies in the first instance to the whole of the states of Arunachal Pradesh, Himachal Pradesh, Mizoram, and Sikkim, and the Union Territories. And it shall also apply to such other state which adopts this act by resolution passed in their behalf under clause 1 of Article 252 of the Constitution. That means in future it was applicable to other states also. It shall come into force at once in the states of Arunachal Pradesh, Himachal Pradesh, Mizoram, and Sikkim, and the Union Territories on such date as the central government may by notification appoint, and in any other state which adopts this act under clause 1 of Article 252 of the Constitution on the date of such adoption. And any reference in this act to the commencement of this act shall, in relation to any state or union territory, mean the date on which this act comes into force in such state or union territory, provided that different dates may be appointed for different categories of clinical establishments and for different recognized systems of medicine. So in India, we have several different systems of ministries. In this act, unless the context otherwise requires, authority means the district registering authority set up under section 10. It registers these clinical establishments. Certificate means certificate of registration issued under section 30. Then clinical establishment means a hospital, maternity home, nursing home, dispensary, clinic, sanatorium, or an institution by whatever name called that offers services, facilities requiring diagnosis, treatment or care for illness, injury, deformity, abnormality, or pregnancy in any recognized stream or system of medicine established and administered or maintained by any person or body of persons, whether incorporated or not. So this is the definition of clinical establishment. Or a place established as an independent entity or part of an establishment referred to in subclause 1 in connection with the diagnosis or treatment of disease where pathological, bacteriological, genetic, radiological, chemical, biological investigations or other diagnostic or investigative services with the aid of laboratory. That is all the say labs or pathological labs, etc. These are also covered under clinical establishments. Or other medical equipment are usually carried on, established and administered or maintained by any person or body of persons, whether incorporated or not. So these are also, these labs have also been defined as a clinical establishment, what we call as paramedical, and shall include clinical establishment owned, controlled, or managed by the government or a department of the government, a trust, whether public or private, a corporation, that is including a society registered under a central, provincial, or state act, whether or not covered by the government, local authority, and a single doctor. So these are, we can say, the different legal statuses that are recognized by this act, but does not include the clinical establishments owned, controlled, or managed by the armed forces. That is, this is not applicable to the armed forces, hospitals, etc. For the purposes of this clause, armed forces means the forces constituted under the Army Act 1950, the Air Force Act 1950, and the Navy Act 1957. So these three acts have been, or the army establishments have been, military establishments have been excluded from this act. Emergency medical condition. It means a medical condition manifesting itself by acute symptoms or sufficient severity, including severe pain of such a nature that the absence of immediate medical attention could reasonably be expected to result in placing the health of the individual, or with respect to a pregnant woman, the health of the woman or her unborn child in serious jeopardy, or serious impairment to bodily functions, or serious dysfunction of any organ or part of the body. This is called emergency medical condition. Next is the National Council. So under this act, there is National Council for Clinical Establishment has been established under Section 3. Notification means a notification published in the official gazette. Prescribed means prescribed by rules made under this act by the central government, or as the case may be by state government. So both the governments have the rule making power. Recognized system of medicine. Now in India, there are several systems that are recognized. These include allopathy, yoga, naturopathy, Ayurveda, homeopathy, Siddha, and Unani system of medicines. Even we have Ayush Ministry in India that looks after these alternative systems of medicines, or any other system of medicine as may be recognized by the central government. So these are the different recognized systems of medicine in India. Then register means the register maintained by the authority, state government and the central government under sections 37, 38 and 39 respectively of this act, containing the number of clinical establishments registered. Then we have registration means to register under section 11, and the expression registration or registered shall be construed accordingly. So this is the definition. Next we see rules. So it means rules made under this act. Schedule means the schedule appended to this act. Standards means the conditions that the central government may prescribe under section 12 for the registration of clinical establishment. So all the clinical establishments have to meet these standards. State government in relation to a union territory means the administrator thereof appointed under Article 239 of the Constitution. We have already seen that this act is applicable to the UTs also. To stabilize with its grammatical variations and cognate expressions means with respect to an emergency medical condition specified in clause D, to provide such medical treatment of the condition as may be necessary to assure with a respectable medical reasonable medical probability that no material deterioration of the condition is likely to result from or occur during the transfer of the individual from a clinical establishment. That is called stabilize. Then we come to chapter 2. So there is National Council for Clinical Establishment. So with effect from such date as the central government may by notification appoint in this behalf, there shall be established for the purposes of this act a council to be called the National Council for Clinical Establishments. Now the composition is given here in subsection 2. So the National Council shall consist of Director General of Health Services, Ministry of Health and Family Welfare, ex officio, who shall be the chairperson, 4 representatives each of out of each to be elected by the Dental Council of India, constituted under section 3 of the Dentist Act 1948, Medical Council of India, constituted under section 3 of the Indian Medical Council Act 1956. Now this act has been repealed and it has been replaced by the NMC Act of 2019. National Medical Commission has come into effect. There is Nursing Council of India, constituted under section 3 of the Indian Nursing Council Act 1947. Pharmacy Council of India, constituted under section 3 of the Pharmacy Act 1948. So there shall be 4 representatives each from one of these councils, besides the DG of Health Services. 3 representatives to be elected by the Central Council of Indian Medicine, representing the Ayurveda, Siddha and Unani systems of medicine, constituted under section 3 of the Indian Medicine Central Council Act 1970. So there is representation by all these different alternative systems of medicine in India. 1 representative to be elected by the Central Council of Homeopathy, constituted under section 3 of the Homeopathy Central Council Act 1973. 1 representative to be elected by the Central Council of the Indian Medical Association. This is a non-government body in India. 1 representative of Bureau of the Indian Standards, that is BIS, constituted under section 3 of the Bureau of Indian Standards Act 1986. So this is the composition. Besides that, it would have 2 representatives from the Zonal Council set up under section 15 of the States Review Organization Act 1956. 2 representatives from the Northeastern Council set up under section 3 of the Northeastern Council Act 1971, and 1 representative from the line of paramedical systems, including systems that have been given representation under clause B. So this is the composition of National Council. Further, it would have 2 representatives from national level consumer group to be nominated by the central government, 1 representative from the Association of Indian System of Medicine relating to Ayurveda, Siddha and Unani to be nominated by the central government, and Secretary General of the Quality Council of India ex officio. Coming to subsection 3, the nominated members of the National Council shall hold office for 3 years, but shall be eligible for re-nomination for maximum of one more term of 3 years. So it could be 3 or 3 plus 3, that is 6 years. Elected members of the National Council shall hold office for 3 years, but shall be eligible for re-election. So there are nominated members as well as the elected members, provided that the person nominated or elected, as the case may be, shall hold office for such period till he holds appointment to the office by virtue of which he was nominated or elected to the council. This is for the ex officio members, that is, members who are there by virtue of their offices. The members of that means as soon as they seize that office, they would be seizing their seat in this National Council also. The members of the National Council shall be entitled to such allowances as may be prescribed by the central government. The National Council may, subject to the previous approval of the central government, make bylaws fixing a quorum and regulating its own procedure and the conduct of all business to be transacted by it. And the National Council shall meet at least once in 3 months. This is the frequency of meetings, that is, 4 meetings every year, 1 meeting every 3 months. National Council may constitute subcommittees and may appoint to such subcommittees as it deems fit persons who are not members of the National Council for such period not exceeding 2 years for the consideration of particular matters. So this council has power to appoint members. Then on such subcommittees, the functions of National Council may be exercised notwithstanding any vacancy therein, and the central government shall appoint such persons to be the secretary of the National Council as the central government may prescribe, and may provide the National Council with such other secretarial and other staff as the central government considers necessary. Coming to the next section, that is disqualifications. So a person shall be disqualified for being appointed as a member of the National Council if he has been convicted and sentenced to imprisonment for an offence which in the opinion of the central government involves moral turpitude, or is an undischarged insolvent, or is of unsound mind and stands so declared by a competent court, or has been removed or dismissed from service of the government or a corporation owned or controlled by the government, or has in the opinion of the central government such financial or other interest in the council as is likely to affect prejudicially the discharge by him of his functions as a member. Then under section 5, we see what are the functions. So the National Council shall compile and publish National Register of Clinical Establishment within 2 years from the date of the commencement of this act. So this came into effect in 2010. Classify the clinical establishments into different categories and develop the minimum standards and their periodic review. Determine within a period of 2 years from its establishment first set of standards for ensuring proper healthcare by the clinical establishments, collect the statistics in respect of clinical establishments, and perform any other function determined by the central government from time to time. Coming to section 8, there is power to seek advice or assistance. So the National Council may associate with itself any person or body whose assistance or advice it may desire in carrying out any of the provisions of this act. Then National Council to follow consultative process. So National Council shall follow a consultative process for determining the standards and for classification of clinical establishments in accordance with such procedure as may be prescribed. Then coming to chapter 3. Now, just as at central level there are state councils, similarly at state level we have state councils. So registration and standards for clinical establishments. So state council of clinical establishments. So every state government shall by notification constitute a state council for clinical establishments or the union territory council for clinical establishments as the case may be. Now the composition. So the state council or the union territory council as the case may be shall consist of the following members, namely Secretary Health ex officio who shall be the chairman, Director of Health Services ex officio member secretary, and directors of different streams of Indian systems of medicine as ex officio members, and one representative each to be elected by the executive committees of State Medical Council of India, State Dental Council of India, State Nursing Council of India, and State Pharmacy Council of India. So these are the elected members. We have seen that there are certain elected members as well as there are certain nominated members. Now 3 representatives to be elected by the executive of the State Council or the Union Territory Council as the case may be of Indian medicine, representing the Ayurveda, Siddha and Unani systems of medicine. 1 representative to be elected by the State Council of the Indian Medical Association. This is a non-governmental organization in India. 1 representative from the line of paramedical systems, and 2 representatives from state level consumer groups or reputed non-governmental organizations working in the field of health. The nominated member of the State Council or the Union Territory Council as the case may be shall hold office for a term of 3 years but shall be eligible for renomination for maximum of 1 more term of 3 years. So we have seen that this is similar to the National Council. The elected members of the State Council or the Union Territory Council, as the case may be, shall hold office for 3 years but shall be eligible for re-election, provided that the person nominated or elected, as the case may be, shall hold office for so long as he holds the appointment of the office by virtue of which he was nominated or elected by the State Council or the Union Territory Council, as the case may be. That is, this is for the ex officio members. That is, when they cease their substantive office, so they would cease their office in the or sit in the State Council as well. The State Council or the Union Territory Council shall perform the following functions, namely, compiling and updating the state registers of clinical establishment, sending monthly reports for returns for updating the national register, representing the state in the national council, and hearing of appeals against the orders of the authority, and publication or on annual basis a report on the state of implementation of standards within their respective states. Then we have section 9, that is providing information to National Council. So it shall be the responsibility of the State Council for Clinical Establishments to compile and update the state register of clinical establishments of the state, and further to send monthly returns in digital format for updating the national register. Then their authority for registration. So the state government shall, by notification, set up an authority to be called the District Registering Authority for each district for registration of clinical establishments with the following members, namely, District Collector is the chairperson, District Health Officer is the convener, and 3 members with such qualifications and on such terms and conditions as may be prescribed by the central government. So this is the authority for registration. Under subsection 2, notwithstanding anything contained in subsection 1, for the purposes of provisional registration of clinical establishments under section 14, the District Health Officer or the Chief Medical Officer, that is CMO, by whatever name called, shall exercise the powers of the authority as per procedure that may be prescribed. Section 11 is about registration for clinical establishment. So no person shall run a clinical establishment unless it has been duly registered in accordance with the provisions of this Act. So this makes it mandatory, the registration for clinical establishments where this Act is applicable. Then there is, say, condition for registration, that for registration and continuation, every clinical establishment shall fulfill the following conditions, namely, the minimum standards of facilities and services as may be prescribed, the minimum requirement of personnel as may be prescribed, provisions for maintenance of records and reporting as may be prescribed, and such other conditions as may be prescribed. Under subsection 2, the clinical establishment shall undertake to provide within the state, within the staff and facilities available, such medical examination and treatment as may be required to stabilize the emergency medical condition of any individual who comes or is brought to such clinical establishment. So this is the emergency subsection 1, and provided that in prescribing the standard for clinical establishment, the central government shall have regard to the local conditions. Now we are coming to chapter 4 of this Act. So there is the procedure for registration that is prescribed. So application for provisional certificate of registration. So for the purposes of registration of the clinical establishment under section 10, an application in the prescribed form along with the prescribed fee shall be made to the authority. The application shall be filed in person or by say post or online, and the application shall be made in such format shall be accompanied by such details as may be prescribed under this Act or rules made thereunder. So this is how to apply for registration. After application, they get the certificate of registration. So if any clinical establishment is in existence at the time of commencement of this Act, an application for its registration shall be made within 1 year from the date of the commencement of this Act, and a clinical establishment which comes into existence after commencement of this Act shall apply for permanent registration within a period of 6 months from the date of its establishment. So they are given 6 months, that is within 6 months registration has to be obtained. If any clinical establishment is already registered under any existing law requiring registration of such establishments, even then it shall apply for registration as referred to in subsection 1. So if it is already registered, then it will be re-registered. Now there is a sorry, the authority shall within a period of 10 days from the date of receipt of such application grant to the applicant a certificate of provisional registration in such form and containing such particulars and such information as may be prescribed. So this is about the provisional certificate is obtained within 10 days. Then there is say under section 16, no inquiry prior to provisional registration. That is, it is immediately given. So authority shall not conduct any inquiry prior to the grant of provisional registration. Notwithstanding the grant of the provisional certificate of or registration, the authority shall, within a period of 45 days from the grant of provisional registration, cause to be published in such manner as may be prescribed all particulars of the clinical establishment so registered provisionally. So within 45 days from the grant, they will have to say give all the particulars of registration. Now the validity. So the validity is prescribed here. That is 1 year. So subject to provisions of section 23, every provisional registration shall be valid to the last day of the 12th month from the date of issue of the certificate of registration, and such registration shall be renewable. Now there is also permanent registration. So there is display of certificate of registration. That is, the certificate shall be kept affixed in a conspicuous place in the clinical establishment in such manner so as to be visible in everyone visiting such establishment. Then there is duplicate certificate. So in case the original certificate is lost, destroyed, or mutilated or damaged, the authority shall issue a duplicate certificate on the request of the clinical establishment and on the payment of such fees as may be prescribed. Then certificate to be non-transferable. So certificate of registration shall be non-transferable, and in the event of change of ownership or management, the clinical establishment shall inform the authority of such change in such manner as may be prescribed. Then in the event of change of category or location, or on ceasing to function as a clinical establishment, the certificate of registration in respect of such clinical establishment shall be surrendered to the authority, and the clinical establishment shall apply afresh for grant of certificate of registration. So this is the provision for the surrender of certificate. Then there is publication of expiry of registration. So authority shall cause to be published within such time and in such manner as may prescribe the names of clinical establishments whose registration has expired. Then there is renewal of registration. So the application for renewal of registration shall be made 30 days before the expiry of the validity of the certificate of provisional registration. And in case the application for renewal is made after the expiry of the provisional registration, the authority shall allow renewal of registration on payment of such enhanced fees as may be prescribed. So within 30, that is 30 days before the expiry, renewal has to be applied for. And again, if there is delay, then there will be additional fees that needs to be paid, enhanced fee. Now the time limit. So where the clinical establishments in respect of standards have been notified by the central government, provisional registration shall not be granted or renewed beyond the period of 2 years from the date of notification of the standards in case of clinical establishments which came into existence before the commencement of this act. So maximum, there is the validity period of the registration. This is 2 years. And the period of 2 years from the date of notification of the standards for clinical establishment which came into existence after the commencement of this act, but before the notification of the standards, and the period of 6 months from the date of notification of standards for clinical establishment which came into existence after the standards have been notified. So this is the time limit for the provisional registration, that is 2 years and 6 months. Now there could be permanent registration also. So 24 section 24 provides for that. So application for permanent registration by clinical establishment shall be made to the authority in such form and be accompanied by such fees as may be prescribed. Section 25 is about verification. So the clinical establishment shall submit evidence of having complied with the prescribed minimum standards in such manner as may be prescribed. So this ensures the quality standards for the establishment. Then there is display of information for filing objection. So as soon as the clinical establishment submits the required say evidence of having complied with the prescribed minimum standards, the authority shall cause to be displayed for information of the public at large and for filing objections, if any, in any such manner as may be prescribed. All evidence submitted by the clinical establishment of having complied with the prescribed minimum standards for a period of 30 days before processing or grant of permanent registration. Then there is 27, that is communication of objections. So if objections are received within the period prescribed, period referred to in the preceding section, then such objections shall be communicated to the clinical establishment for response within a period of 45 days. So within 45 days, objections have to be communicated if there is denial of certificate. The standards for permanent registration. So permanent registration shall be granted only when a clinical establishment fulfills the prescribed standard for registration by the central government. Then there is allowing or disallowing of registration. So authority shall pass an order immediately after the expiry of the prescribed period and within the next 30 days thereafter, either say allowing the application for permanent registration or disallowing the application, provided that the authority shall record its reasons if it disallows an application for permanent registration. So reasons have to be recorded in case of denial. Now there is certificate of permanent registration. So just like there is provisional, so now there is certificate for permanent registration also. So the authority shall, if it allows an application of the clinical establishment, issue a certificate of permanent registration in such form and containing such particulars as may be prescribed. The certificate shall be valid for a period of 5 years from the date of issue. And for the purposes of subsection 1, the provisions of section 18, 19, 20 and 21 shall also apply. The applications for renewal of permanent registration shall be made within 6 months before the expiry of the validity of the certificate of permanent registration. And in case the application of renewal is not submitted within the stipulated period, the authority may allow renewal of registration on payment of such enhanced fees and penalties as may be prescribed. So there could be enhanced fees and penalties if the application is not made timely for renewal. Then fresh application for permanent registration. So disallowing of an application for permanent registration shall not debar a clinical establishment from applying afresh for permanent registration under section 24 and after providing such evidence as may be required of having rectified the deficiencies on which grounds the earlier application was disallowed. So whenever there is rejection, so they may reapply after overcoming the deficiencies or the objections. Then there is cancellation of registration. So if at any time after any clinical establishment has been registered, the authority is satisfied that the conditions of the registration are not being complied with, or the person entrusted with the management of the clinical establishment has been convicted of an offence punishable under this Act, it may issue a notice to the clinical establishment to show cause within 3 months time as to why its registration under this Act should not be cancelled, or for the reasons to be mentioned in the notice. And if after giving a reasonable opportunity to the clinical establishment, the authority is satisfied that there has been a breach of any of the provisions of this Act or any rules made thereunder, it may by an order without prejudice to any other action that it may take against such clinical establishment, cancel its registration. So the authority has power of cancellation. And every order made under subsection 2 shall take effect where no appeal has been preferred against such order immediately on the expiry of the period prescribed for such appeal. So these orders are appealable. And where such appeal has been preferred and it has been dismissed from the date of the order of such dismissal, provided that the authority after cancellation of registration for reasons to be recorded in writing may restrain immediately the clinical establishment from carrying on if there is imminent danger to the health and safety of patients. So in such cases, cancellation is done. Now there is provision for inspection of registered clinical establishment. So the authority or an officer authorized by it shall have the right to cause an inspection of or inquiry in respect of any registered clinical establishment, its building, laboratories and equipment, and also of the work conducted or done by the clinical establishment to be made by such multi-member inspection team as it may direct, and to cause an inquiry to be made in respect of any other matter connected with the clinical establishment, and that establishment shall be entitled to be represented thereat. The authority shall communicate to the clinical establishment the views of that authority with reference to the results of such inspection or inquiry. That is, the report has to be given, and may, after ascertaining the opinion of the clinical establishment thereon, advise the establishment upon the action to be taken. So there a report shall be submitted to the clinical establishment. Then the clinical establishment shall report to the authority the action, if any, which is proposed to be taken or has been taken upon the results of such inspection or inquiry, and such report shall be furnished within such time as the authority may direct. That is, it may overcome the deficiencies and then submit report to the inspecting authority. Where the clinical establishment does not within a reasonable time take action to the satisfaction authority, it may, after considering any explanation furnished or representation made by the clinical establishment, issue such directions within such time as indicated in the directions as the authority deems fit, and the clinical establishment shall comply with such directions. So this is as far as the inspection is concerned. Now there is also power to enter. So the authority or an officer authorized by it may, if there is any reason to suspect that anyone is carrying on a clinical establishment without registration, enter and search in any manner prescribed at any reasonable time, and the clinical establishment shall offer reasonable facilities for inspection or inquiry and be entitled to be represented thereat, provided that no such person shall enter the clinical establishment without giving notice of his intention to do so. So there is power to enter. Then there is levy of fees by the state government. So state government may charge fees for different categories of clinical establishments as may be prescribed. That is prescribed by rules. Then there is provision for appeal. So any person aggrieved by an order of the registering authority refusing to grant or renew a certificate of registration or revoking a certificate of registration may, in such manner and within such period as may be prescribed, prefer an appeal to the State Council, provided that the State Council may entertain an appeal preferred after the expiry of the prescribed period, if it is satisfied that the appellant was prevented by sufficient cause from preferring the appeal in time. And every appeal under subsection 1 shall be made in such form and be accompanied by such fee as may be prescribed. So this is the appeal provision. Then coming to chapter 5, there is register of clinical establishment that is to be maintained. So the authority shall within a period of 2 years from its establishment compile, publish and maintain in digital format a register of clinical establishments registered by it, and it shall enter the particulars of the certificate so issued in a register to be maintained in such form and manner as may be prescribed by the state government. So this registration is published and it is also now available in digital format. Then register of clinical establishments. So under subsection 2, each authority, including any other authority set up for the registration of clinical establishments under any other law for the timing in force, shall supply in digital format to the State Council of Clinical Establishments a copy of every entry made in the register of clinical establishments in such manner as may be prescribed, to ensure that the state register is constantly up to date with the registers maintained by the registering authority in the state. Coming to section 38, so maintenance of state register. So every state government shall maintain in digital and in such format containing such particulars as may be prescribed by the central government a register to be known as the state register of clinical establishment in respect of clinical establishments of that state. So there are registers at central level as well as state level. And every state government shall supply in digital format to the central government a copy of the state register of clinical establishments and shall inform the central government all additions to and other amendments in such register made for a particular month by the 15th day of the following month. So it has to be done periodically. Coming to section 39, establishments of national register of clinical establishments. So central government shall maintain in digital format an all India register to be called as the national register of clinical establishments that shall be an amalgam of the state register of clinical establishments maintained by the state governments and shall cause the same to be published in digital format. So from the state register, the national register is constructed. There are penalties also. So under section 40, whoever contravenes any provisions of this act shall, if no penalty is provided elsewhere, be punishable for the first offence with fine which may extend to 10,000 rupees, for any second offence with fine which may extend to 50,000 rupees, and for any subsequent offence with fine which may extend to 5 lakh rupees. So from 10,000 to 5 lakh rupees is the penalty. There is also monetary penalty for non-registration. So whoever carries on a clinical establishment without registration shall on first contravention be liable to a monetary penalty up to 50,000 rupees, for second contravention with a monetary penalty which may extend to 2 lakh rupees, and for any subsequent contravention with a monetary penalty which may extend to 5 lakh rupees. Then whoever knowingly serves in a clinical establishment which is not duly registered under this act shall be liable to a monetary penalty which may extend to 25,000 rupees. This is penalty to the employees. For the purpose of adjudging under subsections 1 and 2, the authority shall hold an inquiry in the prescribed manner after giving any person concerned a reasonable opportunity of being heard for the purpose of imposing any monetary penalty. So show cause notice has to be given. While holding an inquiry, the authority shall have power to summon and enforce the attendance of any person acquainted with the facts and circumstances of the case to give evidence or to produce any document which in the opinion of the authority may be useful for or relevant to the subject matter of the inquiry, and for if on such inquiry it is satisfied that the person has failed to comply with the provisions specified in subsections 1 and 2, it may by order impose the monetary penalty specified in these subsections to be deposited within 30 years of the order in the account referred to in subsection 8 of section 42. So this is the power that is given to this authority. While determining the quantum of monetary penalty, the authority shall take into account the category, size and type of the clinical establishment and local conditions of the area in which the establishment is situated, and any person annoyed aggrieved by the decision of the authority may prefer an appeal to the state council within a period of 3 months from the date of the said decision, and the manner of filing the appeal referred to in subsection 6 shall be such as may be prescribed. Then coming to section 42, if there is disobedience of direction, obstruction and refusal of information. So whoever willfully disobeys any direction lawfully given by any person or authority empowered under this act to give such direction or obstructs any person or authority in the discharge of any functions within such person or authority is required or empowered under this act to discharge shall be made to a monetary shall be liable to a monetary penalty which may extend to 5 lakh rupees. Then whoever being required by or under this act to supply any information willfully withholds such information or gives information which he knows to be false or which he does not believe to be true shall be liable to a monetary penalty which may extend to 5 lakh rupees. And for the purpose of adjudging under subsections 1 and 2, the authority shall hold an inquiry in the prescribed manner after giving any person concerned a reasonable opportunity of being heard for the purpose of imposing any monetary penalty. And while holding an inquiry, the authority shall have power to summon and enforce the attendance of any person acquainted with the facts of the and circumstances of the case to give evidence or to produce any document which in the opinion of the authority may be useful for or relevant to the subject matter of the inquiry. We can say it is a quasi-judicial proceeding. And if on such inquiry it is satisfied that the person has failed to comply with the provisions specified in subsections 1 and 2, it may by order impose the monetary penalty specified in these subsections to be deposited within 30 days of the order in the account referred to in subsection 8. In subsection 5, while determining the quantum of monetary penalty, the authority shall take into account the category, size, and type of the clinical establishment and local conditions of the area in which the establishment is situated. And any person aggrieved by the decision of the authority may prefer an appeal to the state council within a period of 3 months from the date of the state decision. So appeal can be made if there is say adverse decision of the authority to the state council. The manner of filing the appeal referred to in subsection E shall be such as may be prescribed, and the monetary penalty levied under sections 41 and 42 shall be credited to such account as the state government may by order specify in this behalf. Then there is penalty for minor deficiencies under section 43. So whoever contravenes any provisions of this act or any rule made thereunder resulting in deficiencies that do not pose any imminent danger to the health and safety of any patient and can be rectified within a reasonable time shall be punishable with fine which may extend to 10,000 rupees. Under section 44, if there are contravention by companies, now since company can't be imprisoned, so the office bearers or say managing director, manager, chairman, so they can be punished. So where a person committing contravention of any of the provisions of this act or of any rule made thereunder in a company, every person who at the time of the contravention was committed was in charge of and was responsible to the company for the conduct of the business of the company as well as the company shall be deemed to be guilty of the contravention and shall be liable to fine, provided that nothing contained in this subsection shall render any such person liable to any punishment if he proves that the contravention was committed without his knowledge or that he had exercised all due diligence to prevent the commission of such contravention. And notwithstanding anything contained in subsection 1, where a contravention of any of the provisions of this act or of any rule made thereunder has been committed by a company, and it is proved that the contravention has taken place with the consent or connivance of or is attributable to any neglect on the part of any director, manager, secretary, or other officer of the company, so director, manager, secretary, or other officer shall also be deemed to be guilty of that contravention and shall be liable to fine. And for the purposes of this section, company means a body, corporate, and includes a firm and other association of individuals. So when we talk of company, we have to consider that company has got a very broad meaning. Company doesn't mean company under Companies Act only. Company also includes firm under Partnership Act or Limited Liability Partnership. It also includes any other association of individuals. That is company. And director in relation to a firm means a partner in the firm. Then offences by government departments. So in that the head of the department is generally liable. So where an offence under this act has been committed by any department of government within a period of 6 months after the commencement of this act, the head of the department shall be deemed to be guilty of the offence and shall be liable to be proceeded against and punished accordingly. Provided that nothing contained in this section shall render such head of the department liable to any punishment if it proves that the offence was committed without his knowledge or that he exercised all due diligence to prevent the commission of such offence. This provision is similar to that we have seen earlier for companies and firms. And notwithstanding anything contained in subsection 1, where an offence under this act has been committed by a department of government and it is proved that the offence has been committed with the consent or connivance of or is attributable to any neglect on the part of any officer other than the head of the department, such officer shall also be deemed to be guilty of that offence and shall be liable to be proceeded against and punished accordingly. So even the other government employees may be punishable, liable to punishment. And recovery of fine. So whoever fails to pay the fine, the state government or clinical establishment may prepare a certificate signed by an officer authorized by it specifying the fine due from such person council or any officer authorized in this behalf in respect of anything which is in good faith or intended to be done in pursuance of the provisions of this act or any rule made thereunder, and no suit or other legal proceeding shall lie against the state government or the central government in respect of any loss or damage caused or likely to be caused by anything which is in good faith done or intended to be done in pursuance of the provisions of this act or any rule made thereunder. So this is the protection of action taken in good faith for implementing this act. And furnishing of returns, etc. So every clinical establishment shall within such time or within such extended time as may be prescribed in that behalf furnish to the authority or the state council or the national council such returns or the statistics and other information in such manner as may be prescribed by the state government from time to time. There is power to give directions. So without prejudice to the foregoing provisions of this act, the authority shall have the power to issue such directions, including furnishing returns, statistics, and other information for the proper functioning of clinical establishments, and such directions shall be binding. So this authority has the power to give directions. There is employees of the authority, etc., to be public servants. That is, they are maybe prosecuted under this within definition of section 21 of IPC. So every employee of the authority, the national council and the state council shall be deemed to, when acting or purporting to act in pursuance of any of the provisions of this act, be public servants within the meaning of section 21 of the Indian Penal Code. That is, they can be prosecuted for corruption, etc. Power to remove difficulties. So if any difficulty arises in giving effect to the provisions of this act, the central government may, by order established in the official gazette, make such provisions not inconsistent with the provisions of this act as may appear to be necessary or expedient for removal of the difficulty, provided that no such order shall be made after the expiry of a period of 2 years from the date of commencement of this act. So within 2 years, this order to power to remove difficulties order can be made. Every order made under this section shall, as soon as may be after it is made, be laid before each House of Parliament. Then power of central government to make rules. So this is the rule making power. The central government may by notification make rules of carrying out all or any of the provisions of this act. In particular and without prejudice to the generality of the foregoing power, such rules may provide for all or any of the following matters, namely, allowances for the members of the National Council under subsection 5 of section 3, appointment of such person to be the secretary of the state council by the central government under subsection 10 of section 3, and the determination of standards and for classification of clinical establishments under section 7, and the qualification and the terms and conditions for the members of the authority under clause C of subsection 1 of section 10. The procedure under which the powers of the authority may be exercised by the district health officer or chief medical officer for the purpose of provisional registration of clinical establishment under subsection 2 of section 10, and the minimum standards of facilities and services under clause 1 of subsection 1 of section 12, and the minimum number of personnel under clause 2 of subsection 1 of section 12, and the maintenance of records and reporting by the clinical establishment under clause 3 of subsection 1 of section 12. Then the other conditions for registration and continuation of clinical establishment under clause 4 of subsection 1 of section 12, classification of clinical establishment under subsection 1 of section 13, the different standards for classification of clinical establishments under subsection 2 of section 13, the minimum standards for permanent registration under section 28, the form and particulars to be contained in the register to be maintained under section 38. So this is as far as the rule making powers of the central government are concerned. So every rule made by the central government under this act shall be laid as soon as may be after it is made before each House of Parliament while it is in session for a total period of 30 days, which may be comprised in one session or in 2 or more consecutive sessions. And if before the expiry of the session, immediately following the session or the successive sessions aforesaid, both houses agree in making any modification in the rule, or both houses agree that the rule should not be made, The rule shall thereafter have effect only in simplified form or be of no effect as the case may be. So, however, that any such modification on annulment shall be without prejudice to the validity of anything previously done under that rule. So, this is generally the rule making procedure for under all the acts where the central or the state government has the rule making powers. Then there is power of state government to make rules. So, state government may by modification make rules for carrying out in respect of matters which do not fall within the purview of section 52. In particular and without, that is, we can say residuary power. In particular and without prejudice to the generality of the foregoing provision of power, such rules may provide for all or any of the following matters, namely the pro forma and the fee to be made for the registration under subsection 1 of section 14, the form and details of obligation under subsection 3 of section 14, the particulars and information contained in certificate of provisional registration under section 15, the manner of publication of all particulars of the clinical establishments proposed to be registered under subsection 3 or 2 of section 16, the fees to be paid to issue a duplicate certificate under section 19, the change of owner to be informed by the clinical establishment to the authority under subsection 2 of section 20, the manner in which the authority shall publish the names of the clinical establishments whose registration expired under section 21, the enhanced fees to be charged for renewal after expiry of the provisional registration under section 22, the form of the registration and fees to be charged by the state government under section 24, the manner of submitting evidence of the clinical establishments having complied with the minimum standards under section 25, the manner of displaying information of the clinical establishments having complied with the minimum standards for filing objection under section 26, the expiry of period specified in section 29, the form and particulars of the certificate of registration under section 30, the period within which an appeal shall be preferred under clause A of subsection 3 of section 33, the manner of entry and search of clinical establishment under section 34, the fees to be charged by the state government for different categories of clinical establishment under section 35, the manner and the period within which an appeal may be preferred to the state council under subsection 1 of section 36, the form and the fee to be paid for an appeal under subsection 2 of section 36, the form and the manner in which the register will be maintained under subsection 1 of section 37, then the manner of supply to the state council in digital format, the entry made in the register of clinical establishment under subsection 2 of section 37, the manner of holding an inquiry by the authority under subsection 3 of sections 41 and 42, the manner of filing the appeal under subsection 7 of sections 41 and 42, the manner and the time within which the information to be furnished to the authority or the state council or the national council as the case may be under section 48, and any other matter which is required to be or may be prescribed by the state government. These are the rule making powers of the state government. Now the manner of making the rules. So they have to be laid before the assembly. So every rule made by the state government under this section shall be laid as soon as maybe after it is made before each house of the state legislature where it consists of 2 houses or where such legislator consists of 1 house before that house. That is, we have bicameral as well as unicameral legislature in states. The last section is savings. So provisions of this act shall not apply to the states in which the enactments specified in the schedule are applicable. So there is a schedule to this act, and provided that the states in which the enactments referred to in subsection 1 are applicable, and such states subsequent to the commencement of this act adopt this act under clause 1 of article 252 of the constitution, the provisions of this act shall subsequent to such adoption apply in that state. So we have seen that initially this act applied only to 4 states, and later on other states may also adopt it. So central government may, as and when considered necessary by notification, amend the schedule, that is to which these states may apply. Now, as far as the state governments are concerned, so we have that is under section 56, this schedule is there, and there are at state level, state government has the powers. So what are these acts? In Andhra Pradesh, we have the Andhra Pradesh Private Medical Care Establishments Registration and Regulation Act 2002. In Bombay, Maharashtra, we have this Bombay Nursing Homes Registration Act 1949 that is applicable. It was applicable to Gujarat also, because this Bombay was then divided into Maharashtra and Gujarat. Saurashtra was a different state at that time before 1960. Delhi Nursing Homes Registration Act 1953. Madhya Pradesh Upacharya Griha Tatha Rujopchar San Babdu Sthapumoy, that is Registrikaran Tatha Anugyapan Adhiniyam 1973. So Madhya Pradesh has its own act. Manipur Homes and Clinics Registration Act 1992. Nagaland Healthcare Establishments Act 1997. Orissa Clinical Establishments Control and Regulation Act 1990. In Punjab, we have Punjab State Nursing Home Registration Act 1991. West Bengal has its own act, West Bengal Clinical Establishments Act 1950. So these are some acts at the state level. Then there are some categories that are given. So definition for classification and categorization of clinical establishments is given. So clinical establishment, we have already seen that it means hospital, maternity home, nursing home, dispensary, clinic, sanatorium, or an institution by whatever name called that offers services, facilities requiring diagnosis, treatment, or care for illness, injury, deformity, abnormality, or pregnancy in any recognized system of medicine, established and administered or maintained by any person or body of persons, whether incorporated or not, or is a place established as an independent entity or part of an establishment referred to in suppose one in consonance connection with the diagnosis or treatment of disease, whether pathological, bacteriological, genetic, radiological, chemical, biological investigations or other diagnostic or investigations relative services with the aid of laboratory or other medical equipment as usual are usually carried on, established and administered or maintained by any person or body of persons, whether incorporated or not. Then there is classification. So classification means the action or process of classifying something according to shared qualities or characteristics. Categorization is the process in which ideas and objects are recognized, differentiated, and understood. Hospital bed means WHO defines a hospital bed as a bed that is regularly maintained and say staffed for the accommodation and full-time care of a succession of inpatients. Because there are two types of patients under hospital, inpatients and OPD, that is outpatient department. So these wards are for inpatients and is situated inwards or a part or of the body of the hospital where continuous medical care for inpatients is provided. The total of such beds constitute the normally available bed complement of the hospital. That is, we talk about the capacity of the hospital, how many beds. There are two types of patients as we have seen. Inpatients, that is residents hospitalized for indoor care across all types of hospital beds. Outpatients are where care is provided without admission or hospitalization as inpatient. Clinics means a medical facility run by a single or group of physicians or health practitioners smaller than a hospital. This is the definition of clinic. Clinics generally provide only outpatient services and can have an observation bed for short stay. So this is clinic and how it differs from the hospital. Then there is daycare facility, that is medical or surgical. So daycare facility as part of an existing hospital. Here it is in the form of service offered by any hospital on its own premises or as extension outside its premises. Responsibility of the day center will be of parent organization or institution or hospital, and daycare facility specific to a specialty, that is ophthalmic services, ENT services, etc. This center should have referral mechanisms in place, that is in place of need of the patient can be shifted to a link hospital already identified, and this referral mechanism should be displayed prominently. There is also hospital definition. So hospital as per WHO means healthcare institutions that have an organized medical and other professional staff and inpatient facilities and deliver medical, nursing and related services 24 hours per day, 7 days per week. That is, they are open round the clock. Hospitals offer a varying range of acute, convalescent and terminal care using diagnostic and curative services in response to acute and chronic conditions arising from diseases as well as injuries and genetic anomalies. In doing so, they generate essential information for research, education, and management. Traditionally oriented on individual care, hospitals are increasingly forging closer links with other parts of the health sector and communities in an effort to optimize the use of resources for the promotion and protection of individual and collective health status. This is the definition of hospital and how it differs from clinic. Now there are hospital levels that are defined in India. So under Clinical Establishment Act 2010, the allopathic hospitals will be broadly defined under following 4 levels. We call it level 1A, that is general medical services with indoor admission facility provided by recognized allopathic medical graduates and may also include general dentistry services provided by recognized BDS graduates, that is Bachelor of Dental Surgery. Example, PHC, that is primary health center, government and private hospitals, and nursing homes run by MBBS doctors, etc. Then we have second level, that is hospital level 1B. This level of hospital shall include all the general medical services provided at level 1A above and specialist medical services provided by doctors from one or more basic specialties, namely general medicine, general surgery, pediatrics, obstetrics and gynecology and dentistry, providing indoor and OPD services. So level 1 and 1B hospitals shall also include support systems required for the respective services like pharmacy, laboratory, etc. Example is general hospital, single or multiple basic medical specialties provided at community health center, sub-divisional hospital, and private hospital of similar scope, nursing homes, civil or district hospital in few places, etc. Then we have level 2, that is non-teaching hospital, because we have hospital as well as we have medical colleges, and medical colleges have necessarily to be accompanied by say 100-bed hospital as per the norms for medical colleges. So here we classify them into non-teaching. So hospital which is not say we can say associated or affiliated to a teaching institution. So this level may include all the services provided at level 1A and 1B and services through other medical specialties given as under, in addition to basic medical specialty given under 1B like orthopedics, ENT, ophthalmology, dental, emergency with or without ICU, anesthesia, psychiatry, skin, pulmonary medicine, rehabilitation, etc. and support systems required for the above services like pharmacy, laboratory, imaging facilities, operation theatre, etc. The examples are district hospital, corporate hospitals, referral hospital, regional or state hospital, nursing home, and private hospital of similar scope, etc. So this is called hospital level 2, that is non-teaching. Then we have non-teaching super specialty services. In India, we have super specialty services also at like postgraduate institutes or AIMS, etc. This level may include all the services provided at level 1A, 1B, and 2, and services of one or more of the super specialty with distinct department and or also dentistry if available. If it will have other support systems required for services like pharmacy, laboratory, and imaging facility, operation theatre, etc. Examples are corporate hospitals, referral hospitals, regional or state hospital, nursing home, and private hospital of similar scope, etc. That is hospital level 3. And then we have hospital level 4, that is teaching, which are associated with the medical colleges. So this level will include all the services provided at level 2 and may also have level 3 facilities. It will, however, have the distinction of being teaching or training institution, and it may or may not have super specialties. That is, they could be for MBBS, or they could even be for MD or DM, doctorate in medicine, or PhD or PDCC, that is postdoctoral certificate courses. Tertiary healthcare services at this level can be provided through specialists and maybe super specialists if available, like in case of AIMS, PGI, JIPMER Pondicherry, Sanjay Gandhi PGI of Medical Sciences at Lucknow, PGI Chandigarh, etc. These are examples of tertiary healthcare institutes. It will have other support systems required for these services. Now we have AIMS in many states in India. It shall all India Institute of Medical Sciences. It shall also include the requirement of MCI or other registering body for teaching hospitals and will be governed by their rules. Now MCI has been replaced by the NMC in India, National Medical Commission. However, registration of teaching hospitals will also be required under Clinical Establishment Act for purpose other than those covered under MCI, such as records maintenance and reporting of information and statistics, and compliance to range of rates for medical and surgical procedures, etc. So there are certain regulations for these also. Then there are hospital levels, that is nursing home. So nursing home means any premises used or intended to be used for reception of persons suffering from any sickness, injury, or infirmity, and providing of treatment and nursing for them, and include a maternity home. Then there is definition of maternity home. So maternity home means any premises used or intended to be used for reception of pregnant women or a woman in labor or immediately after childbirth. There is also a general hospital. General hospital is a setup having facilities, medical staff, and all necessary personnel to provide diagnosis, care, and treatment of a wide range of acute conditions, including injuries, and normally has an emergency department to deal with immediate and urgent threats to health. So this is the 12th level of hospital. The 13th is definition is that of specialty hospital. So these are hospitals having facilities, medical staff, and all necessary personnel to provide diagnosis, tertiary care, and treatment of a limited specialized group of acute or chronic conditions such as psychiatric problems, certain disease categories such as cardiac, oncology, or orthopedic problems, and so forth. There is also multi-specialty hospitals. These are hospitals offering specialized and tertiary care in single or multiple facilities, segregated units, each of which are devoted to be a complexity of patient care defined in this subsection, and they could have dozens of different departments. There are also dental clinics. So these are places where dentists provide dental care with no inpatient facilities. There are dental hospitals. So they are places where dentists provide outpatient dental care with inpatient facilities. There is also diagnostic center. It means standalone organized facilities to provide simple to critical diagnostic procedures such as radiological investigation supervised by radiologists and clinical laboratory services by laboratory specialists, usually performed through referrals from physicians and other healthcare facilities. These are the diagnostic centers. Then there are clinical or medical diagnostic laboratory. It means a laboratory with one or more of the following, where microbiological, serological, chemical, hematological, hematological, immunological, toxicological, cytogenic, exfoliative, cytogenic, uh, histological, pathological, or other examinations are performed, or material or fluids derived from the human body for the purpose of providing information on diagnosis, prognosis, prevention, or treatment of disease. So these are the different labs like path labs, pathology labs, and other labs. So these are clinical and medical diagnostic laboratories. Then there are categories of clinical establishments based on location, ownership, systems of medicine, type, size, services offered, specialty, etc. These are as follows. So the location may be rural, urban, or metro, or notified inaccessible areas, including hilly or tribal areas. So these are 4 locations. Ownership may be either government or public. So it could be of central government, state government, local government, municipality, Jilla Parishad, etc., public sector undertaking, other ministries and departments, railways, police, etc., employee state insurance corporation. ESI also has many hospitals, autonomous organization under government, non-government or private, individual proprietorship, partnership, registered companies registered under the Central Provincial State Act, and society or trust registered under the Central Provincial State Act. Besides that, we have already seen that there are also military hospitals under Army, Navy, and Air Force. So these are separate. Then categories of clinical establishments also includes systems of medicine in the establishment. That is, there could be allopathy, that is modern medicine, any one of multiple disciplines of Ayush as defined by the Ministry of Ayush, Government of India. According to type or size. So type and size of clinical establishment shall be as under. There are clinics, that is outpatient. So clinics shall be categorized as follows: single practitioner, that is consultation services only with diagnostic services with short stay. We have also, many of you might have heard this word polyclinic, that is many doctors come together and different types of doctors offer different services. So there are consultation services only with diagnostic services or with short stay. So they are called polyclinics. There are also dispensing hospitals and there are health checkup centers. Then we have daycare facility. So there are medical, surgical, there is also medical SPA, wellness centers, that is where qualified medical professionals are available to supervise the services. There are also hospitals including nursing home, outpatient and inpatient. So a healthcare institution providing patient treatment by specialized staff and equipment. The hospitals including nursing homes should be categorized based on the following criteria. So there is general practice, single specialty, multi-specialty, that is including palliative care center, trauma center, maternity home, and super specialty. So this is based on the specialties. And then we have medical and surgical specialty and super specialty. So these are different fields that have been recognized. So the fields of clinical, medical, and surgical specialty and super specialty shall be as per list of Medical Council of India regulation, and currently it will cover following. That is medical specialties for which candidates must possess recognized postgraduate degree of MD, that is Doctor of Medicine or Diploma, or its equivalent recognized degree or diploma. So what are these specialties? There is anesthesiology, aviation medicine, community medicine, dermatology, venerology and leprosy, family medicine, general medicine, geriatrics, immunohematology and blood transfusion, nuclear medicine, pediatrics, physical medicine, rehabilitation, psychiatry, radio diagnosis, radiotherapy, rheumatology, sports medicine, tropical medicine, tuberculosis and respiratory medicine or pulmonary medicine. Then there are surgical specialties. This is as far as MS degree is concerned, Master of Surgery. So for which candidates must possess recognized degree of MS or diploma or its equivalent recognized degree. So these are otorhinolaryngology, general surgery, ophthalmology, orthopedics, obstetrics and gynecology, including MTP, medical termination of pregnancy, and artificial reproductive techniques, that is ART centers. There are medical super specialties. These include cardiology, clinical hematology, including stem cell therapy, clinical pharmacology, endocrinology, immunology, medical gastroenterology, medical genetics, medical oncology, neonatology, nephrology, neurology, and neuroradiology. Then there are surgical super specialties. This includes cardiovascular, thoracic surgery, urology, neurosurgery, pediatric surgery, plastic and reconstructive surgery, surgical gastroenterology, surgical oncology, endocrine surgery, gynecological oncology, and vascular surgery. There are definition of services provided. So as regards to a definition of services provided at specialty and super specialty or multi-specialty allopathic hospitals, the same shall be categorized based on level on care into hospital level 1A, 1B, 2, 3 non-teaching and 4 teaching. So these are the 5 different levels that are available. Then there are dental clinics and dental hospitals. So these are dental clinics, single practitioner, polyclinics, dental specialties as listed in the Indian Dental Council Act, oral and maxillofacial surgery, oral medicine and radiology, orthodontics, conservative dentistry and endodontics, periodontics, pedodontics and preventive dentistry, oral pathology and microbiology, prosthodontics and crown bridge, and public health dentistry. These are the branches of dentistry. Then there are diagnostic centers. So medical diagnostic laboratories. So there are two main types of labs that process the majority of medical specimens. These are hospital laboratories that are attached to a hospital and perform tests on patients. There are private or community laboratories. So there is a sample from general practitioners, insurance companies, clinical research sites, and other health clinics for analysis. These can also be called reference laboratories, where more unusual and obscure tests are performed. So clinical laboratories could be general labs and or advanced labs that provide services in the following fields, that is pathology, biochemistry, microbiology, molecular biology, and genetic labs and virology. There are diagnostic imaging centers. So these diagnostic imaging centers could be general and or advanced that provide following services, that is radiology, general radiology, interventional radiology, electromagnetic imaging, magnetic resonance imaging, MRI, positron image, emission tomography, PET scan, and ultrasound. There are collection centers. So collection centers for the clinical labs and diagnostic centers shall function under registered clinical establishment. The above list is not exhaustive. Section 13(1) under the clinical establishments registration and regulation at 2010 reads, clinical establishment of different systems shall be classified into such categories as may be prescribed by the central government from time to time. So these classifications may also be changed. There are allied health professionals. So allied health professionals generally indicate that they are health professionals distinct from medicine, dentistry, pharmacy, and nursing. That is, we have medical as well as paramedical. The list of allied health professionals includes, but is not limited to, the following disciplines: audiology, behavioral health, that is counseling, marriage and family therapy, etc., exercise physiology, nuclear medicine technology, medical laboratories, dietetics, occupational therapy, optometry, and orthotics. Then orthotics and prosthetics, osteopathy, paramedic, pediatry, podiatry, health psychology, clinical psychology, physiotherapy, radiation therapy, radiography, medical imaging, respiratory therapy, sonography, and speech pathology. Under Ayush, we have many alternative systems of medicine in India. This covers Ayurveda. It has Aushad Chikitsa, Shalya Chikitsa, Shodhan Chikitsa, Rasayana, Pathya Vyavastha. In yoga, we have Ashtang Yoga. In Unani, we have Matab, Jarhat, Ilaj Bit, Tadbir, Hifjan-e-Sehat. Then Siddha. This has Maruthuvam, Sirapu Maruthuvam, Varman Thuknam, and Yoga. In homeopathy, we have general homeopathy, and naturopathy, we have external therapies with natural modalities, internal therapies. We also have separate Ministry of Ayush under Government of India. The above list is not exhaustive, and Section 31 under the Clinical Establishments Registration and Regulation Act 2000 reads, clinical establishment of different systems shall be classified into such categories as may be prescribed by the central government from time to time. So this is about the Ayush. So that completes this presentation. So I'm thankful to Dr. Ravindra for giving me an opportunity to make this long presentation. I am thankful to all the patients, participants also for patient listening. Are there any questions? If there are any questions, I'll be glad to answer them. Well, I would like to add lastly that I was myself working in a hospital, Sanjay Gandhi Postgraduate Institute of Medical Sciences, and I have computerized that entire hospital because I am a computer engineer. After doing engineering, I had never thought that I would ever work in a hospital, but I was appointed in charge of computer center, and I computerized that entire hospital from 1998 to 2000 with the help of CDAC, Center for Development of Advanced Computing, New Delhi, and IIT Kanpur. So I worked in a hospital and computerized, and earlier I was facing difficulty even to remember the names of all the different departments there. But when I came to know about the human body and different things in biology that I had forgotten, so I computerized that hospital, SGPG IMS Lucknow. So that is my, I also have experience of working in a hospital for more than 2 years.
Thank you very much.
Thank you, sir.
It was presented. So participants, if you have any queries, you can feel free to share feedback, suggestions in chat box or raise your hand. Yeah, we can understand, it's a very elaborate acts and so for some people it may be jargon also, but some, at least we know that what are the provisions, various, that are included and that are not included, at least as part of it. And anything, in detail, you can always consult legal professionals, like even our Virendra Kumarji is there, and you can reach out to him or anyone nearby you for any kind of suggestions or for that. This anything, it is always better. We see a lot of, clinics and lot of consultation rooms, especially not as clinics, but we see lot of consultation rooms nowadays seen without registration. So, as a practitioner, we are at risk, and as a, client, they are also at risk when a clinic is not registered because it doesn't have a legal sanctity. So that is always better to register when you are doing your own practice, or even when you are working. We have seen that there are penalties also working under an unregistered clinic. So hope this has provided wonderful insights into various aspects of delivering the services by professionals, various professionals. Thank you, Virendra Kumarji, taking all the time. It was a busy schedule for me as well, and as well as for you, and taking time to join us. And we had a very good conclusion, as we are commemorating this psychology month, psychology week, psychology day this month, and today last day of the month. It was indeed a very insightful session and enlightening session as well. So you all can access this recording on the website. And after this conference, actually we were waiting to conclude this conference. So today, after this, you can fill the feedback form. We will be sending an email today. And the feedback form for the entire conference will also be updated on website. Kindly fill up the feedback form and complete your formalities. From tomorrow morning onwards, we'll process the data, and accordingly, we'll be issuing all the certificates, whoever is eligible. So thank you, Virendra Kumarji, once again for joining.
Thank
you, and we wish you all the success.
Thank you, sir. Thanks to Dr. Ravindra. Thanks to all the participants also. Thank you for giving me this opportunity to make these two presentations. That is on Mental Healthcare Act as well as its Clinical Establishments Act. Thank you so much. Good night to all.
Thank you, Virendra Kumarji, once again. And we would like to express our sincere, heartfelt gratitude to all the speakers who have presented in this conference. And we wish you all a happy learning and also success in your future endeavors. And we also express our sincere gratitude to all the participants. Hope you have lot of takeaways through various sessions over the past 1 week. And you have been patiently encouraging, listening to all the sessions. And definitely, all the speakers, presenters are indebted to you because you have spared your valuable time for your encouragement, participation, and your presence. So we'll be sharing, we'll be concluding now, and before concluding, we'll be raising a feedback form within the Zoom platform. Kindly fill up the feedback form. Then after this conclusion, we will also send you an email, and you can also access the feedback form for the entire conference. You can share in brief what is your learning, and if you have any suggestions, feedback. And as a last chance, we have, while filling up the feedback form, so I saw some message in the chat box. Sulata P. Okay, if you want to make a presentation, so okay, while the participants are filling up the feedback form, you can make a presentation. So that can be the last presentation, but share your details. And a sincere request from our side is kindly complete the formalities as mentioned on the website. It's really difficult. Even we are also at helpless state because time is very important factor for all of us. And in tight schedules, we have to work. So ensure that you all are completing your formalities. We cannot look into things manually. See, it happens, if you are joining for the sake of certificate, there is nothing wrong for that. But there is a system and we all need to follow, because at the end of the day, we are the one who have to follow the system, and system has to generate certificates. So for that, we are the ones who have to process it. So if you don't feed it like it's a computer, if you don't feed it with right data, it will not give the output. If you feed junk, it will give you junk only. So make sure you are filling up all the details correctly, and ensure that you complete all the things in time. That is also important. So we already gave you 2 days for completing formalities. Hope everyone, those who have presented, have shared all the details. And that's why we said tomorrow we will start processing, and we will start generating certificates. First, you will be getting quiz certificates, as that has fewer formalities. So those who have not completed quiz, you can immediately fill the quiz form and complete it. So we will keep it open, even for some time. So no need to worry. Those who want to fill and submit the quiz will be issuing certificates. But try to understand that it will be not issued immediately. You have to wait, maybe weekly once, or maybe after a month, you may get a certificate for that. Because already now we will be issuing certificates on day-to-day basis. We cannot issue. Earlier it was there, whoever has filled, they got. But what we found is, lot of certificates generated without proper data. And once it generated, we cannot recall back. The certificate is already issued, and we cannot do anything. We can just only mention it as cancelled. So these things have happened a lot. We have seen daily, day in and day out. So that's why all the automatic generation, I mean, it will be generated, but only after, thorough verification, then certificates are updated and being shared. So actually, the direct drive link, all the certificates are generated automatically. But we are giving access only after we are manually verifying. Before generating the certificate. So entire process is automatic only, but the final output we are checking and we are issuing, we are processing it for generation of certificates. So we are also soon planning to, actually we have been continuously improving to process these certificates, but it's all depends on the input. Because of that, certificates are getting delayed or not generated because input is directly given by you. So we don't enter anything from our side. And that we all should understand that we are not giving any data which is manually entered from our side. Whatever data you are entering in Google Forms, in Zoom forms are directly taken by system. Even the email sent to us in the format is also processed by system. We check, but the processing automatically, the format has been programmed in the system, and it will take, if there is a line saying name, it will automatically take after semicolon, it will, whatever is the data, it will take it and compare. So even an extra space unnecessarily will also have an issue. But of course, we have taken care with exceptions to handle such things. So system automatically is cleaning the data also. But, all these things will increase the workload on the system, and we cannot assure you that your certificate will be generated automatically. So that's why be cautious. My sincere request is don't make any request to me, because you do your work sincerely, wholeheartedly, automatically things will be done automatically. And no need to, contact me or anyone in the technical team. It's not required basically. If you are not getting certificate, then cross-check yourself where things have gone wrong. Automatically, you can resolve it yourself. So I am telling that you are the only person who can solve your problem. We are just facilitators here. See, you have come, you have shown interest, you have taken decision to participate, and we are facilitating you. So you have registered, and we have checked the minimum criteria, and that is satisfying. So we have allowed you, and you have completed your presentation. So every step we are clearing doubt. And once you complete your presentation or participation, it is your responsibility to again feed the system with the feedback. Once feedback is given, it will check the registration data, whether you have registered or not. That is first criteria. Second criteria is whether you have attended or not. that Zoom attendance, the reports or data generated by Zoom. And that's why your name as registered in the Google form. So the name of that the name you have entered in the Google form should match the name of the participant list in the Zoom. So this is where many people lose their certificates. You are not using the same name. You are using different name. And also, we have identified it long back, and that's a problem. And not everyone is so technology friendly. So what we have done, we have incorporated the manual entry saying that, oh, I have not shared feedback form yet. So let me share the feedback form. So you can keep filling it and I can give you the instructions. Okay. So now the feedback form is on. So where I am, that's why when we see some messages in between, this is the problem. We'll get lost in the flow. So, okay, what I was explaining. Yeah, fill the feedback form, and once this data is processed, the same data sets should be same. What I'm telling you is why many people face problem here in the certificates is these are the common mistakes you make. That is the problem. You don't listen to instructions. So it is not just you, even we also, even I also have to fill for each event. I also have to register because I am also a volunteer. I also have to register if I need a certificate. Generally, coordinators do not get any certificate, because we are the ones who organize taking, though of course it is organized by the organization, but generally that is an attendance for me, just like I have spent my time here. So it is for that sake only, nothing else. So we request everyone to follow the instructions. If you don't follow, then we can't do anything. So that's why register and use the same name, same data, or even if you are using, different data, at least keep some value same. See, name is same for no matter, how many presentations you make, participation you make, name is always same. You have the same format as it is mentioned on your certificates. So fill the data correctly. And we see many people don't fill the city. When we say educational qualifications, here we see this student also, they are simply mentioning student. Now, student of what, which college, which institution, that also you have to mention. Otherwise, there is no, and at the place they just mention India or some other country. Now, this kind of vague data, we are issuing certificates for that also because we have your email ID, we have your mobile number, but that is not, proper data. That's what I'm telling you, where mistakes are happening. You fill it properly, seriously. Tomorrow if you have to get verified or your certificate have to get verified, then there are no details here in this system except your mobile number, except your registration number. I mean, registered email ID, mobile number, your name. There are no other details. Now, these kind of problems, now who is responsible for all of this? You are only responsible. You are not providing data. Now, how we will get data to verify? So this is where, especially on this platform, the problems whoever is facing is only because of not following instructions. They think that they will get anyway, like other platforms. Other platforms have their own agendas, their own system. So they take money and they keep people for that. The investment, they get funding for organizing events. But here we don't have, we also get funding, but we are denying funding. We don't need any funding for this because it is what we can do. Whatever we are doing is within our, capacities by God's grace. And this is only purely to support people like all of us to share knowledge. So use it properly, utilize it properly, and get all the benefits. Earlier, we used to manually do each and everything, but now we don't have time. Really, we are saying. And we'll not charge also. There are many people saying, kindly take some amount also and manually verify. You can also put some charges and manually verify certificates and give. That is not possible. That is not at all the policy. We thought earlier to have premium membership and differentiate, but even for that also we didn't get any proper response. We have, as per like many participants have said, we are ready to pay and kindly provide, reduce the formalities and pay. But the response was very low. Just only some, though we had thousands of participants, hundreds of participants, but the form we got through the response when we floated was very low. So there is no point in making it. So we just kept it aside. So again, this is the problem. When we are taking a suggestion also, when it is not being accepted, so there is no point in anyway, there is no point in putting some fees or charges. It's not required also in very first place. If you do it correctly, automatically things will fall correctly. Don't expect, others to do your job completely. You will get certificates. If you don't do, then you will not get certificates because it is a system, that's all. So we wish you all happy learning. And even that's why we have kept a registration form, feedback form open. So if you have done some mistake, kindly go back, rectify it and fix it. And once certificates are generated, we cannot go back doing again. So already we have given you time. We are giving you time, more time by tomorrow morning. Tomorrow we will start processing the data sets. So those who have not completed, kindly complete by tomorrow morning or immediately now, as early as possible. So tomorrow, once the data is processed, the certificates will be generated. Those who are eligible, those who have completed all these formalities, they will be getting their certificates in another 3 to 5 working days. But tomorrow we'll start processing. At any time in the next 3 to 5 working days, you can check website and certificates will be updated in this. So if you can't find your certificate, that means you have not completed the formalities properly. One thing is you have not at all filled it. Other maybe you have not properly filled it. So check yourself, fill it, and don't be in a panic mode, just like entering and, like you are doing, there is no other person sitting on this side, 24 hours waiting for you to fill and immediately issue. It is not possible here. So you have to wait for some time. It may take hours, days, weeks, months also. Depends on how late you provide your input. So that's why completing in time is also very important. So happy learning. Hope you all enter your data properly so that you all will receive certificates automatically getting updated on the website, and no certificate will be sent to your email ID. I'm telling you once again, people are messaging, I haven't received certificate. You will not receive any certificate to your email ID or WhatsApp, or you have to visit the website and you have to download it. To generate that certificate, you need to complete this format. So thank you once again, everyone. Happy learning. I hope along with you, at least we all are learning continuously on this platform. We have different personalities. We have different people. We are seeing continuously those who are coming, attending, participating, presenting, collaborating. So it's a very good opportunity for all of us. Thank you once again. Take care. Good night.